Yeah, he's been here.
All right, let's next take up the matter of the state of Wisconsin versus Lee L. Hagopian, 21 CM 393. May I have the appearances, please?
State appears by ADA Jennifer Phan.
Thank you. May I, Mr. Lee Hagopian, would you unmute your device, please, sir?
All righty.
Thank you, sir. Are you Lee L. Hagopian?
I am.
Did you, were you served or did you receive a copy of the criminal complaint, sir?
I did, Your Honor. I
You,
received it.
listen to me. Did you read the criminal complaint?
Yes, I did.
Do you understand the charges brought against you and the maximum penalty for those charges, sir?
I do not understand, and that's why I would ask the state and the court to grant a continuance so I can understand. This was filed on the 19th, and I've had barely any time to understand it. That's why I don't understand.
Here's what we're going to do today. I'm not going to grant a continuance. If you want, we'll have it read to you completely, but we're going to move your case forward today, sir. So do you need the complaint? First off, do you understand the charges brought against you and the maximum penalty for those charges?
I do not understand, Your Honor.
All right. Then, Ms. Vaughn, would you read this entire complaint, please, to Mr. Hagopian at this time?
Well, the undersigned being first duly sworn states that count 1, practice optometry without license. The above named defendant on or about Wednesday, October 16, 2019 in the village of Paddock Lake, Kenosha County, Wisconsin, did practice optometry within the meaning of 449.01 sub 1 sub A without a license to do so and a valid certificate of registration issued by the examining board, contrary to section 449.02 sub 1 and 449.11 with stats, a misdemeanor, and upon conviction for the first offense may be fined not less than $50, no more than $200, or in prison not more than 3 months or both. Count 2, misdemeanor theft. The above named defendant on or about Wednesday, October 16, 2019 in the village of Paddock Lake, Kenosha County, Wisconsin, did obtain title to property of Jill Gilmore by intentionally deceiving the person with a false representation which he knew to be false, made with intent to defraud, and which defrauded the person contrary to section 943.20 sub 1 sub D and sub 3 sub A, 939.51 sub 3 sub A with stats, a class A misdemeanor, and upon conviction may be fined not more than $10,000 or in prison not more than 9 months or both. Count 3, obstructing an officer. The above named defendant on or about Tuesday, January 14, 2020 in the village of Paddock Lake, Kenosha County, Wisconsin, did knowingly obstruct an officer while such officer was doing an act in the official capacity and with lawful authority by making false statements during the course of an investigation, including denying giving contact lenses to Gilmore, contrary to section 946.41 sub 1, 939.51 sub 3 sub A, with stats, a class A misdemeanor, and upon conviction may be fined not more than $10,000 or in prison not more than 9 months or both. Probable cause section. Detective Barnett of the Kenosha Sheriff's Department reports that he was assigned to assist the Kenosha DA's office with the complaint reported to the DA's office by the Wisconsin Department of Safety and Professional Services, DSPS. Detective Barnett reports that he is aware that DSPS is the regulatory and investigative authority regarding optometry complaints. The complaint was filed with DSPS by Jill Gilmore in reference to a possibly illegal optometry business run by Lee Hagopian, hereinafter the defendant. Detective Barnett reports that the complaint involved Next Day Glasses, which is located at 7419 256 Ave in the village of Paddock Lake, County of Kenosha, state of Wisconsin. Gilmore had made the report to DSPS on October 23, 2019, regarding an incident occurring on October 16, 2019. In that report, Gilmore stated that on October 16, 2019, she had called Next Day Glasses in Paddock Lake asking him to set up an appointment. Gilmore stated that she asked the man on the phone if she could set up an appointment to be seen and get glasses. The man said yes and asked when she would like to come in. Gilmore stated that the man mentioned that if she had a prescription in the last 5 years, he could get her in and out of his office pretty quick. The man was unable to get her an appointment at 12:15. The man was able to get her an appointment at 12:15 p.m. the same day. Gilmore stated that she was greeted at the door by the same man who she spoke to on the phone. Gilmore stated that she later found out that this man was Lee Hagopian, the defendant. Gilmore stated that she assumed that this was the secretary until the defendant asked her to sit down into a chair and look at a picture until it became clear. Gilmore stated that the defendant looked at her current glasses and said it was going to give her a stronger prescription for her right eye and that she would like it. Gilmore stated that they also talked about her wanting to get contacts, so he said that he would give her a trial pair. Gilmore stated that she was to wear the trial pair for 2 hours that night, 4 hours the next day, and by the third day, she should be able to wear them full time. Gilmore stated that she picked out a pair of glasses, a pair of sunglasses, and 6 months worth of contacts. Gilmore stated that she gave the defendant her VSP insurance information, address, and phone number. Gilmore stated that the defendant said that she gets $150 off her first pair of glasses, so those would be $99. Gilmore stated that he said it was $89 for the exam, $199 for a scratch coat, high index, anti-reflective, and UV coat. Gilmore stated that it was $199 for 6 months of contacts at a discount and $199 for the sunglasses at a discounted rate. Gilmore stated that he gave her the price of $759 after taxes and a processing fee. Gilmore stated that she paid and the defendant gave her a bag. Inside the bag was a carbon copy of the receipt that had a bunch of prices on it and a bunch of stamps on it, a set of trial contacts, contact solution, and wedding drops. Gilmore stated that she got home and that afternoon she put the contacts in her eyes. Gilmore stated that she left them in for 2 hours as directed. After 2 hours, she took them out. Gilmore stated that within the next 45 minutes, her eyes were on fire and burning and itching. Gilmore stated that she went to look at the contact packs and they expired in 2011 and 2012. Gilmore stated that she called the glasses that evening and the defendant answered the phone. Gilmore stated that she asked him why he gave her an expired trial pair of contact lenses and told him that her eyes were very itchy and hurting. Gilmore stated that the defendant told her it was probably just an allergy and she should use the drops, also expired, that he gave her and that he was closed and would take the call in the morning. Gilmore stated that by morning she had taken 2 doses of Benadryl with no relief. Gilmore stated that her husband asked her to go see his eye doctor and another doctor fearing that she had an infection in her eyes. Gilmore stated that at that point she contacted her bank, her VSP insurance, and her husband's eye doctor to set up an appointment that afternoon. Gilmore stated that during the process she was told that Next Day Glasses was a scam and she should not return there. Gilmore stated that she called Next Day Glasses to let them know that she was going to see another doctor because her eyes had not gotten better. Gilmore stated that the defendant answered the phone and asked her to come into his office right away and that he wanted to flush her eyes out right away. Gilmore stated that she would not be coming in until 5:00 p.m. when her husband could come along with her. Gilmore stated that the defendant then proceeded to call every 15 minutes for the next hour or so. The defendant left a message stating that the contact manufacturer told him that she probably was just having a reaction to the contacts and that she should come in and get some different drops from him at no cost. Gilmore stated that she went to Antioch Eye Care where she was seen by Dr. Bean. Gilmore stated that she experienced horrible pain and Dr. Bean put a numbing drop in her eye so he could do the exam. Gilmore stated that Dr. Bean learned that her left eye had an injury that was open and that an infection had started. Gilmore stated that she was prescribed antibiotic eye drops. Gilmore stated that she and her husband called Next Day Glasses and the defendant answered. Gilmore stated that they let him know that they would not be coming in and that they would never be returning to his office. Gilmore stated that they asked him to cancel the glasses, sunglasses, and 6 months worth of contact lenses. Gilmore stated that the day after this conversation, the bank was working to stop payment and asked her to contact the defendant to see if he would refund the $759. Gilmore stated that she called Next Day Glasses and asked the defendant to process the refund, and the defendant told her that she had to come into his office first so he could see if she was lying to him. Gilmore stated that she would only come into his office with a police escort, and the defendant started getting upset with her, so she just hung up. Gilmore stated that she notified the bank and let them know she was not comfortable with going back. Gilmore stated that through this whole thing, she was trying to save time by going and getting glasses quickly, and now she has none of the glasses or contacts, just the trial pair of expired contacts. Detective Barnett reports that on January 14, 2020, he and Detective Lieutenant Dan Ruth met with the defendant at Next Day Glasses and Contacts in Paddock Lake. The defendant invited them into the business, and he initially spoke to them in the lobby of the business. They asked the defendant if they could talk to him in his office, and the defendant escorted them to the frame and contact display room that was adjacent to the lobby. Detective Barnett reports that he asked the defendant about the complaint filed by Jill Gilmore. The defendant became defensive and said that he had never performed an eye examination on Gilmore and he never provided Gilmore with contact lenses. The defendant stated that he is not an optometrist and is only a dispensing optician. Detective Barnett asked the defendant what services he provided to Gilmore, and the defendant said he provided Gilmore with 2 pairs of glasses. Detective Barnett asked the defendant about the expired contact lenses that Gilmore received from him, and the defendant again said that he never provided Gilmore with any contacts. Detective Barnett asked the defendant if he had left a voicemail message for Gilmore as indicated in her complaint requesting her to bring the contacts back so he could rinse her eyes. The defendant said that to get Gilmore to come back to the office because she must have taken the contacts without his knowledge or permission because he never gave her any contacts. Detective Barnett reports that he asked the defendant how he provided Gilmore with new glasses as it appeared she never provided the defendant with a prescription. The defendant said he used a refractor on Gilmore and checked her old pair of glasses. The defendant led Detective Barnett and Lieutenant Ruth to his lab, which is a separate room off the lobby, and showed them his refractor. The defendant stated that as an optician, he can use a refractor to check visual acuity. Detective Barnett reports that he saw additional equipment in the lab that was covered by a black tarp. The defendant said the equipment is optometry equipment, but it has not been used in several years since he has had an optometrist on staff. The defendant stated he does not have any professional association with any optometrist, and he does not have one come into his office. Detective Barnett reports that he asked the defendant if he increased the prescription in Gilmore's right eye because the complaint indicated that the defendant had told Gilmore that he was going to give her a stronger prescription for her right eye and she would like it. The defendant claimed that he told Gilmore she may need a stronger prescription for her right eye, but she would need to see an optometrist for a new prescription.
He's nuts.
Detective Barnett reports that he and Lieutenant Ruth then returned to the frame room to continue the interview. Detective Barnett pointed out to Hagopian that according to his website, an optometrist is ready for your eye exam at the business. Hagopian said he does not employ an optometrist, but refers people to Dr. Yang and Antioch if they don't have a valid prescription. Detective Barnett asked the defendant where Dr. Yang's office is located in Antioch, and said he's the optometrist at Walmart. Lieutenant Ruth and Detective Barnett asked the defendant if he and Dr. Yang have a business relationship with each other, and what Dr. Yang would say if he contacted him about the defendant. The defendant said he does not have a business relationship with Dr. Yang, and Dr. Yang would probably not know who he is. The defendant said that Dr. Yang would probably know the defendant's business name, but not his name. Detective Barnett reports that he and Lieutenant Ruth saw a large display of contact lenses in the frame room, and Lieutenant Ruth asked to see a package of the contacts. The defendant looked at the display for several seconds before Lieutenant Ruth said, "Just grab any package." The defendant pulled a package from the display, and the package of contacts showed an expiration date in 2014. Lieutenant Ruth asked the defendant about the expiration date, and the defendant said that he does not give out those contacts. The defendant said that he provides new contacts when someone provides him with a valid contact lens prescription. Detective Barnett reports that they asked the defendant why he keeps the display of expired contacts in the office if he doesn't give them out, and the defendant did not answer that question. The defendant stated that he doesn't give the expired contacts out, but that they're still good to use. The defendant stated that the shelf life of contacts is 5 years, but they're stored in a disinfectant, so they will still be okay after 10 years. Detective Barnett reports that he and Lieutenant Ruth saw a form on the counter inside the room that appeared to be a HIPAA rights form and asked the defendant about the form. The defendant said he has all new customers filled out the form. Detective Barnett asked the defendant why he has a HIPAA form if he's only an optician, because an optician is not a medical professional requiring HIPAA compliance, as he is not a doctor. Any records he keeps are not considered medical records. Lieutenant pointed out the signee on the form is identified as a patient on the signature line. The defendant said he calls the client's customers and does not refer to them as patients. The defendant said he could get rid of the HIPAA form. Detective Barnett reports that he and Lieutenant Ruth also located business cards on the counter that indicated that the defendant's business was, quote, under new ownership, unquote. Detective Barnett reports that he asked the defendant about the statement on the card, and the defendant said, quote, that I'll admit is a fib, unquote. The defendant went on to explain that he made new cards containing that statement in case Fox 6 News returns to his business so he can say the business is under new ownership. Fox 6 News previously did an investigative report on the defendant's business. The defendant said that he had been in business for 30 years and has never claimed to be an optometrist. The defendant continued to deny that he provided any eye examination or any contact lenses to Gilmore. Detective Barnett reports that on January 2020, he and Lieutenant Ruth met with Gilmore to go over her complaint and determine if she had any additional information. Gilmore said that the defendant did provide her with sample contact lenses, but did not show her prescription lenses. Gilmore said that she has never before worn contact lenses, but may have had a contact prescription sometime in the past, but she doesn't recall whether or not she did because she has not worn contacts before the defendant provided them to her. Gilmore identified her previous optometrist as Barnett Wambolt Eye Care in Kenosha. Gilmore could not remember if she ever had a contact lens prescription from Barnett Wambolt Eye Care, so she contacted their office on speakerphone while Detective Barnett listened to the conversation. Barnett Wambolt Eye Care confirmed that Gilmore never had a contact lens prescription through that business. Detective Barnett reports that Gilmore showed him the items from the defendant, which included the packages for the expired contact lenses. Gilmore said she also received 2 new pairs of glasses in the mail from the defendant after she filed the complaint. Gilmore stated that she has not worn the new glasses. Records from DSPS indicate that in 2015, the defendant was the subject of an administrative injunction from DSPS. The defendant entered into a stipulation and was found to have engaged in the unlicensed practice of optometry. Pursuant to the administrative injunction, unless and until the defendant is properly licensed to practice optometry by the Wisconsin Optometry Examining Board, the defendant was enjoined and prohibited from the practice of optometry in the state of Wisconsin, from using any title that suggests he is authorized to practice optometry in the state of Wisconsin, and from engaging in any conduct or any that in any way implies that he is authorized to practice optometry in the state of Wisconsin. Your complainant is an attorney with the Kenosha County District Attorney's Office who bases her knowledge on this complaint on the official law enforcement agency reports of the Kenosha Sheriff's Department prepared by Detective Barnett, which reports were prepared in the normal course of law enforcement duties. Statements by citizen informants Jill Gilmore, who are eyewitnesses to the facts that relate, and statements by the defendant, which are made contrary to his real interests. The official records of the Wisconsin Department of Safety and Professional Services, DSPS, the Circuit Court for Kenosha County, the Department of Transportation, the FBI III Teletype, the Wisconsin Circuit Court Automated Program, which records are maintained in the normal course of business duties. Electronically signed by Carly McNeil, complainant, subscribed and sworn to me before me on 4/19/21, electronically signed by Zachary Gross, Assistant District Attorney, State Bar number 1105364.
All right, thank you, Ms. Bond. Very good. Now, Mr. Hagopian, the complaint has been read to you in its entirety. You've been given also read to you the counts which were brought against you, the maximum penalty for those counts. Court has also reviewed this complaint. Does find that probable cause exists that the misdemeanor crimes as set forth in the complaint were committed, and further probable cause exists to believe this defendant committed those crimes, and therefore binds this matter over before the Honorable Mary Kay Wagner presiding. What we're going to do now, Mr. Hagopian, we're going to set bond here in just a second. Before I do that, I wanted to indicate to you, while you have the right to represent yourself in this matter, I do not recommend that you or anyone else would represent themselves in a criminal case. Instead, I would recommend you either consider hiring or retaining private counsel to represent you, or contact the State Public Defender's Office in Kenosha County to see if you're eligible for representation. Do we have a correct address for you, sir, listed on this criminal complaint?
Yes, correct.
All right. I've entered not guilty pleas on your behalf, sir. We're now going to set bond in this case.
I don't understand, Your Honor. I do not understand.
You understand clean English. You and I are talking. It was read to you. We're moving this case forward. So
I need time to...
No, you do not at this point. You may need time to get an attorney, but I'm moving your case forward, so don't argue with me. Now,
I'm not arguing. I'm just letting you know
yes,
I don't
understand.
understand.
Thank you very much. Ms. Bond, what is the state's position on bond?
Your Honor, the state is not opposed to a signature bond. We would ask for no contact with Jill Gilmore, as well as no practicing optometry while unlicensed.
All right, thank you. Is there anything you'd like to tell this court that you request the bond be in this case, Mr. Hagopian, or respond to what the state said in terms of its request for bond?
Only thing I have to say is I don't understand. I wish I had more time, because it's been 2 days since I got
I've already answered that question ad nauseum. We're done. Anything else, sir?
No.
Thank you. Then the court will impose a $1,000 signature bond. Non-monetary conditions of bond, sir, are as follows. Here to have no contact at any time, any location, for any reason, through any means with Jill Gilmore. You must not practice optometry in the state of Wisconsin unless you have a valid license to practice optometry. You must appear in court every time when required and not commit further crimes while out on bond. I believe this complaint was written in plain language, plain English language. Readily, it was read to you, and we're going to move the matter forward. So now what we're going to do, I've entered not guilty pleas on your behalf. What we're going to do now is give you the next dates, court dates for your upcoming hearings, sir. And in addition, you must sign this bond in person in room 204 of the Kenosha County Courthouse. That's located at 912 56th Street. You must sign the bond in person no later than Thursday, April 22nd by 4 p.m. Now, you may come earlier, including today if you'd like, but no later than 4 p.m. April 22nd, that's Thursday. Make sure you do sign the bond in room 204, second floor of the courthouse. If you fail to do so, there'll be a warrant issued for your arrest, so make sure you do sign that bond. You understand, sir? You understand?
I understand the bond issue.
All right. Thank you very much, sir.
It's gonna be a DA pretrial, May 28th at 2:40 p.m. and a judicial pretrial before Judge Wagner, June 10th at 8:30. And that will be on your, those dates will be on your bond.
All right, thank you, sir. When you sign the bond, you'll get a copy of the document you sign, and on that document will be those court dates. So that'll conclude your hearing. Thank you very much. You may disconnect.
Let's see this card. Individual on the Galaxy wearing the baseball cap. What is your name?
Hello?